Armed Forces Special Powers Act, AFSPA, 1958. This has been the subject of considerable controversy over the past many years. Even some days ago, an incident happened in the Nagaland state in northeast of India where the security forces fired upon civilians and many of them died. Once again, this has triggered the controversy around AFSPA. There are many supporters of AFSPA. There are many people who strictly oppose AFSPA. Now let's see what this AFSPA Act is, what it was meant for, whether it is really needed today or whether it is time to repeal AFSPA. Let's have a look. The origins of AFSPA, we have to go back to the British period in the 1940s. More specifically in the year 1942, when the British had the challenge to quell the freedom movement. The Quit India movement was going on at that time. So this was a great challenge for the British. At that time, they brought in an emergency law in the form of an ordinance called the Armed Forces Special Powers Ordinance 1942. So AFSPA legacy we can trace back to the British period, as with many other laws in India. Now after independence in the year 1958, the independent state of India, it is passing a law called AFSPA in the year 1958. This was passed to tackle the problem of internal security within India. At the time, in some areas, for example, northeast, many rebel groups were challenging the authority of the Indian state. So many people, they took up weapons to challenge the authority of the Indian state. Some of them were demanding separate states, that is countries at that time. Even now you are able to see such groups in regions like northeast. So this is actually called insurgency. Insurgency refers to groups that take up weapons or arms to challenge the authority of the state, right? So for tackling these groups, the AFSPA was brought in the year 1958. Northeast was just an example. Such situations were seen in other states also. After that, the AFSPA was applied in many states. Remember that AFSPA is a central law. So right now it is in implementation in the states of Assam, Manipur and Nagaland, also in some districts of Arunachal Pradesh. Earlier, a separate act was applied to the state of Punjab. Later, it was repealed in the year 1997. Similarly, a separate act on the lines of AFSPA enacted by the Jammu and Kashmir state. Right now, it is applicable in Jammu and Kashmir also. Right now, the Jammu and Kashmir state has been divided into two UTs, but nevertheless, the act is in force even now. Under AFSPA, there are certain provisions that provides some wide powers to the armed forces, that is security forces, to ensure law and order. Okay, one of the important aspect of this law is that it empowers the central government to declare an area as a disturbed area under section 3 of this act. Disturbed area is nothing but an area or a region where you are able to see problems or clashes between people based on language, religion, ethnicity, caste or other factors. Overall, we can say there should be a challenge to the security. So such areas can be declared as disturbed areas by the center. This can also be done by the governor of a state or by the administrator of a UT in India. So in such disturbed areas, the security forces are given more powers. They can search and arrest people without warrant. Similarly, they can use force or even open fire if they feel that there is a threat to the security situation. If they feel that some rebels or some group of people are trying to attack the security forces and trying to destabilize the law and order, the peace situation, then they can go ahead and use force. They can even go ahead and kill a person if they feel that the situation warrants such action. So such wide ranging powers are given to the security forces under AFSPA. Under section 6, protection is also given to the security forces. They are given immunity from prosecution if they take such actions in order to ensure law and order. So these are the important aspects of this AFSPA Act. Many civil rights activists have vehemently opposed this AFSPA Act. Irom Sharmila, for example, civil rights activist from Northeast, she underwent fasting for many years against this act. Even now, many people, they are opposing this act. They are repealing. They are demanding for repeal of this act. Even some experts appointed by the center to look into these acts have actually recommended repeal of this act. Jeevan Reddy, for example, the committee formed by the center, even this committee recommended repeal of the AFSPA Act. Instead of that, Jeevan Reddy, he proposed that the existing Unlawful Activities Prevention Act of 1967 be amended to provide some powers to the armed forces to take action. What the AFSPA is doing right now, he suggested that this can be given to the existing act. Okay, but even this recommendation was not accepted by the center. Even the second Administrative Reforms Commission, ARC, also suggested repeal of this act. Once again, this was not accepted by the center. There have been many allegations of sexual harassment by some members of armed forces using AFSPA. There are many protests in the northeastern states regarding this issue. Justice Verma, who was appointed to look into the cases of sexual harassment and rape of women, he actually suggested that the allegations of sexual harassments and rape by the armed forces should also be brought under the larger ambit of the law. So even he told that they should not be exempt. There should not be any blanket immunity for the members of the armed forces. In the year 2016, the Honorable Supreme Court of India remarked that there is no blanket immunity. There is no 100% immunity under AFSPA. In case if it is found that a member of the armed forces has misused his power under AFSPA, if he or she has used power in an unwarranted manner where it is actually not needed, then the member of the armed forces can be tried under the normal law. But the problem here is that the center should give its green signal for prosecution of members of the armed forces. In many cases, this has not been given with regard to AFSPA. Some cases can be transferred to the armed forces also, where they are tried under court martial, but even this has not been done under many cases. This is a significant issue when it comes to trying the members of armed forces, security forces under AFSPA. So these are the various issues that we have to take into account. The central government argues that AFSPA is mainly implemented in the disturbed areas. Many of the disturbed areas, we are able to see not just internal security, even external players. Some other countries are also to blame when it comes to the internal security situation. States such as Myanmar and China, they are having nexus with some rebel groups within India, extremist groups within India. So the center argues that AFSPA is still needed. We have to tackle with these forces. So armed forces should be given some amount of leverage and power, discretion to handle these problems. On the other hand, human rights activists, they are arguing that no matter what the situation is, nobody has a right to take away a life by the gun. So it is wrong to label many citizens as enemies of the states. So arguments have been placed on both sides. So in future, it's better to take some action regarding AFSPA. If you are not going to repeal the AFSPA fully, at least we should bring in proper accountability mechanisms under ASPA, so that in case a member of the armed forces is found guilty of a crime, he should be tried within specified timelines. And as Jeevan Reddy, respectable Jeevan Reddy, uh, recommended, we can even think about repealing the AFSPA and using existing mechanisms to ensure internal security, and we can provide adequate leverage for the armed forces. The sooner we take action, it's better for the Indian state as a whole. So let's wait and see in which direction this subject is going to move in future. Let's wait for the best.